Hello, my name's Justin Gow. I and Ali Tascon and Steph Painter are going to deal with some of the new aspects of the coronavirus laws and their criminal implications. They are wide-ranging and they are serious. The coronavirus regulations were passed very recently and they're extraordinary in at least 4 different ways. The first is they remove the fundamental rights of freedom of movement, freedom of assembly and freedom of worship from people in England. The second is they create a criminal offence to leave where you live without a reasonable excuse and expose anyone who does leave without a reasonable excuse to a criminal liability, a criminal conviction and a criminal record. Thirdly, that the reasonable excuses are drafted in such a way as to be so vague as to be impossible for most people to understand. And fourthly, and most remarkably, these regulations have not been approved by any parliamentary vote. With that background, it's worth looking in some detail about more of these. The other feature of them is they were clearly drafted without reference to other organisations or bodies. One of the reasonable excuses for leaving one's house is if you're a minister of religion and you're going to a place of worship. What is strange about that? Well, there are 2 strange things about that. The first thing is that most Anglican or Roman Catholic priests live on the job, so leaving the house to go to a place of worship is a walk of about 5 or 10 seconds. The second is this: the Archbishops of Canterbury and York and the Cardinal Archbishop of Westminster have closed all churches, all mosques are closed, and all synagogues are closed. And so ministers of religion are allowed to leave their house, travel to their places of worship, and presumably stand outside them. The other curious feature of this is how these regulations are being interpreted. There was a case very recently, a woman in Newcastle who was fined £660 under the new coronavirus laws for refusing to tell the police where she lived and why she was travelling. The reasons for this are extraordinary. The first is that she was on a railway station, Newcastle railway station, between platforms and was approached by the British Transport Police. She was taken to custody for 2 days. Now, one may think taking someone into custody during these periods of coronavirus is both unwise, unsafe and a waste of public money. The next thing is this: she never appeared for her hearing. The very first appearance was both her first appearance in her absence and her trial and conviction in her absence. She was fined, as I say, £660. Fortunately, common sense has prevailed, and when she lodged an appeal, the British Transport Police did not oppose it. But it's with that background that we should analyse more carefully what these regulations are, what they say, and what they're going to do in future. There is supposed to be a 3-week checkpoint, and they shouldn't last for more than 6 months. It's interesting to reflect just how carefully these will in fact be checked and how long they will last. There is clearly scope for a lot of interpretation about the laws themselves, and it may be that, rather unfortunately for the members of the public, but fortunately for members of the bar and the solicitors for organisations, there's going to be a lot of work out there. With no further ado, let's now hear from the 2 experts.
Hello, my name is Stephanie Painter, and I'm going to talk you through the restrictions on the freedom of movement that have been imposed by the new Health Protection Coronavirus Restrictions Regulations, which came into effect on the 26th of March. Now, the government has introduced emergency legislation under the Public Health Control of Disease Act 1984. This act provides wide powers to the Secretary of State for Health to control contagious diseases such as the coronavirus. The government have utilised this 1984 Act's emergency procedure under Section 45R to introduce the regulations with immediate effect. The new laws are called the Health Protection Coronavirus Restrictions Regulations 2020, and they impose wide restrictions on the freedom of movement. Now, the regulations are intended to last as long as the emergency period, Regulation 3.1, and it is the Health Secretary who decides when that ends. It was deemed necessary to make this order without a draft being laid before Parliament and approved. Although the regulations technically require parliamentary approval within 28 days, as Parliament is now in recess, this will not happen before the first review date on the 16th of April, as per Regulation 3.2. The long stop date for the regulation's expiry is in 6 months' time, as per Regulation 12. However, the Health Secretary is obliged to keep the need for the restrictions and requirements under review at least every 21 days. There has been no parliamentary scrutiny over these regulations, which impose extraordinary restrictions on the freedom of movement, which, if breached, carry criminal offences. So what does this mean in practice? Regulation 6.1 provides the general prohibition that during the emergency period, no person may leave the place where they are living without reasonable excuse. It is noteworthy that this does not apply to someone who is homeless, as per Regulation 6.4. Now, the term reasonable excuse is not defined, but there are 13 examples listed in the regulations, stating this includes the need, and I will list them. A, to obtain basic necessities, including food and medical supplies for those in the same household. B, to take exercise, either alone or with other members of their household. C, to seek medical assistance. D, to provide care or assistance, including relevant personal care within a certain paragraph of the schedule, to a vulnerable person, or to provide emergency assistance. E, to donate blood. F, to travel for the purposes of work or to provide voluntary and charitable services. G, to attend a funeral. H, to fulfil a legal obligation, including attending court. J, in relation to children who do not live in the same household as their parents or one of their parents, to continue existing arrangements for access to and contact between parents and children. K, in the case of a minister or religion, or worship leader, to go to their place of worship. L, to move house where reasonably necessary. M, to avoid injury or illness or to escape a risk of harm. Now, I've summarised those, and this is not an exhaustive list, but it does impose 2 tests. Firstly, one of reasonableness. And by virtue of the word need that precedes each of those examples, necessity must also be considered. Now, some of these examples that have been provided are vague and open to interpretation. For example, Regulation 6.2b, exercise. This isn't defined. Therefore, it is feasible that someone could argue that a 15-mile walk through various towns, being out all day, is their preferred form of exercise. However, they would have to establish that this was reasonable and necessary, which it arguably is not. As the regulations do not provide any definition in this regard, this is open to interpretation and relies upon people using their common sense, which we unfortunately know cannot always be trusted. The regulations, importantly, impose criminal offences if this prohibition is breached. So, if anyone leaves their house without an excuse, or where their excuse fails these tests of reasonableness and necessity, they could face a criminal conviction. It is therefore very likely that many people could fall foul of this prohibition, and there will be a lot of room for argument over whether someone's excuse passes these tests of reasonableness and necessity. It was reported on Sunday the 29th of March by the Yorkshire Evening Post that the police in Leeds had issued 27 warning notices, and one person had been reported for summons due to their second blatant breach of the regulations within an hour. It is therefore clear that these powers are already being widely used, which will no doubt result in the courts being very busy once they reopen, in dealing with people who have breached these regulations.
Hello, I'm Alejandra Tascon, and I will be discussing the police powers, offences and penalties under the Health Protection Coronavirus Restrictions Regulations of 2020. In summary, the regulations prohibit anybody from leaving the place where they live without a reasonable excuse, and they ban public gatherings of more than 2 people. Closures and restrictions, which under the regulations are said to last until they're terminated by the direction of the Secretary of State, and they must be reviewed every 21 days. You have very helpfully heard from Stephanie as to what the prohibitions are as set out in regulations 4, 5, 6 and 7. Prohibitions which have been put in place in an effort to reduce the spread and bring about consequences for those who don't abide by them. So I will begin by discussing the powers that the police have in relation to the prohibitions and the offences that have been created and the punishments that they carry. So firstly, what are the police powers and where can you find them? The power to enforce breaches of the prohibitions are given to those who are described as relevant persons, and this can be found under Regulation 7. In accordance to Regulation 7, subsection 12, relevant persons are constables, PCSOs, persons designated by the local authority, and persons designated by the Secretary of State. So what can those persons do? Well, they have the power to direct individuals or return them to the place of living. If necessary, they can remove those individuals and return them to the place of living, and in doing so, they may use reasonable force. If the person outside without reasonable excuse is a child, they may direct an individual with care over that child to return them to their home, and they must ensure that the individual with care over that child follows the instructions that are given. They also have a power to disperse gatherings and direct people to return to their homes, and in doing so, they may give reasonable instructions which they consider necessary. As we will have noticed from watching the news the last couple of days, police forces and local authorities across England are exercising powers under Regulation 7 in different ways. Unfortunately, there doesn't appear to be any uniformity in the way in which these powers are being exercised, and some parts of the country are facing stops on roads where individuals are being quizzed about where they are going, officers stopping individuals on the streets and asking whether their journeys are necessary. But it's crucial for these powers to be implemented fairly and equally throughout England if the intended goal behind the regulations is going to be achieved. So what offences do the regulations create, and what are the penalties for those offences? Breaches of the prohibitions, which I outlined in regulations 4 to 7, have been criminalised, and that you can find under Regulation 9.1. Breaches of those prohibitions have been categorised as summary-only offences, with a sentencing option of a fine alone. Under Regulation 11, anybody can be prosecuted by the CPS or a person designated by the Secretary of State for gathering in a public place with more than 2 people, unless they are of the same household, and also they can be prosecuted for leaving the place where they live without a reasonable excuse. For owners of non-essential businesses, they can be prosecuted for leaving their premises open, such as eating restaurants, hair salons, spas and gyms. However, the regulations are silent as to the maximum level of fine, and therefore it would be open to the magistrates' courts to impose a fine as appropriate in the circumstances. But it's very clear from the regulations that taking these matters to court should only be used as a last resort, and those who breach the prohibitions should first be given the opportunity to pay a fixed penalty notice. So where do the powers for fixed penalty notices come from? Under Regulation 10, there is a power for fixed penalty notices to be issued for those who breach the prohibitions. Where a person has been issued with a fixed penalty notice, they must be allowed 28 days to pay. If the 28 days have elapsed and payment has not been made, prosecution may follow. In accordance to Regulation 10, subsection 6, the first fixed penalty notice that will be issued will be for a value of £60, and the notices must specify detailed particulars of the offence committed, time for payment, the amount of the fixed penalty notice, the name and address of the offender, and the methods of payment. As I previously mentioned, the fixed penalty notices will start at a value of £60, but this is a value that can be reduced if payment is made within 14 days of the notice date, and that payment will be reduced to £30. If a person is given a fixed penalty notice for a second time, that second fixed penalty notice will start at £120, and the amount will continue to double for any subsequent fixed penalty notices which are issued to a maximum of £960. Prosecutions are the last resort, and it's clear from the regulations that they ought to only be used for repeat offenders and those who default the fixed penalty notices. The creation of new summary offences comes at an interesting time for the criminal justice system, because the system has taken quite a beating as a result of the virus. Courts across the country are shut, and only necessary and important hearings are taking place with counsel and legal representatives attending remotely. In the Magistrates' Court, it appears that the focus has turned to overnight cases and custodies. And perhaps it may be that the prosecution of new offences will clog the system further. Nevertheless, it is important that people are held accountable for their actions in this pandemic, and it's important that people understand the severity of not staying at home. Despite this, prosecutions should and must be the last resort, and they should be reserved for the most persistent breaches. But there is more than just the health protection coronavirus restrictions regulations that will affect the system, because there will also be offences for those who have used the coronavirus as a weapon. The Director of Public Prosecutions has announced on the CPS website that anybody using the coronavirus as a threat towards emergency and essential workers will face serious criminal charges, and such behaviour will be punishable by up to 12 months in prison. Those offences will be classed under the assaults on emergency workers. But in addition to that, those who cough in the direction, in a threatening manner towards other key workers or members of the public could also face serious criminal charges by way of common assault. So it's clear that the criminal justice system is taking this very seriously, as is the government. And it will be that we will see the impact of the coronavirus on the criminal justice system and the backlog of cases for many more months to come.